Hello and welcome. My name is Jeremy Prichard. I'm a Professor of Criminal Law at the University of Tasmania. And I'm also the Director of the Tasmania Law Reform Institute. And it's my great pleasure to be here with two special guests for LawFest. And we're going to be talking about the Commission of Inquiry and all sorts of things relating to youth justice. We are not 100% sure where our conversation is going to go. Can I start with asking our two guests to introduce themselves? Angela.
Yes, thanks, Jeremy. So my name is Angela Sdrinis. I'm a Melbourne-based lawyer. I run my own practice, which specialises in institutional and historical abuse claims. We proudly opened an office in Tasmania in 2018, and very shortly after opening our office, we realised that there was a lot of this sort of historical abuse allegations going on down here, and it's been quite a journey. Commission of Inquiry, all the things we're going to talk about today. So it's been great to see that there's been a lot of progress in Tasmania on these issues. And I've had the pleasure of working with barristers like Regina. So, that's what brings me here today.
Fantastic. Thank you so much, Angela, honestly. Regina.
Thank you, Jeremy. And I have to say that Angela's experience is incredible. She's got 3-4 decades worth of experience in this field. So to be briefed by someone like Angela, which is what you do when you're a barrister, you're briefed by a solicitor to work as independent counsel, and to be briefed by someone like Angela and work with her on these sorts of cases is an absolute privilege. So Angela, thank you. It's always nice to work with friends.
Thank you, Reggie.
So I'm a barrister, and yes, like I say, please call me Reggie, because that's Reggie, what most of my friends call me.
Good.
Thank you, Jeremy. I started off, I did my degree at the University of Tasmania here in Sandy Bay, at the Sandy Bay campus. Before that, I was at Hobart College for year 11 and 12, and before that, I was at Woodbridge District High School. So I'm a Tassie girl, born, not born and bred, but I was raised here and went to school here. After I finished university, after I finished my law degree, I was associate to the Honourable Chief Justice Alan Blow. Worked for the Commonwealth DPP for just over a year, and then I went off to The Hague, to the International Criminal Court, where I was a prosecutor for 9 years.
Wow. Is that where you met Tim McCormack?
I met him here. He was my lecturer in. I took his very first international criminal law summer school.
Yes.
Subject for one pure reason, and one pure reason alone.
Yeah.
And that was that I had to take equity and trusts with Gino Del Pont the following year, who traditionally failed half the class. So I thought, well, I need to free up some time, so I'm only doing 3 subjects instead of 4 when I take his class. So I thought, what's showing? Right, international criminal law, that sounds interesting, I'll do it. And I did summer school, and I had one of those moments of, I finally know what I'm doing a law degree for. I want to work at this International Criminal Court that's just started up. So I got a job at the International Criminal Court, which was nice. I didn't do any scholarships. I wasn't a straight A student, that's for sure, HD student, but I managed to get a job, and I stayed for 9 years, which took me, to East Africa on mission. Wow. To interview witnesses and take them in court. A lot of victims of sexual and gender-based violence, human rights abuses, that sort of thing. So then we moved back to Australia, to Canberra, and then back to Tassie, mainly because I have young kids there to raise in Tasmania and do exactly what I've done. So it's really great to be back. One of the sad things, but also positive things, is that I actually didn't think that I would be using the experience I gained on the ground in post-conflict zones on how to interview traumatised victims. I didn't think I'd be using those skills back here in Tasmania, but it seems I'm using them on a daily basis for the good of the victims. So that sort of ties back to how I've started working with Angela.
Right. Shall we our next step could be in any different direction. Shall we start maybe, looking backwards and what's happened so far with the Commission of Inquiry, and if you could both bring your perspectives on how the country's going, but particularly how Tasmania's going.
Angela,
I'll start. So there was a Royal Commission into institutional child abuse, a national Royal Commission, which went for 5 years, and actually really shone a light on that issue where, and I hope I'm sort of getting it vaguely right, but the Royal Commission wrote that there had been, I think, 380 investigations and reports and, big sort of, a lot of looking into the issue of historical child abuse in Australia. But despite all of those separate reports, really nothing had ever changed. So the Royal Commission really just did a big sweep over what had been happening in Australia, but also in the various jurisdictions. But it couldn't do everything. And as far as Tasmania was concerned, the Royal Commission did what was called 2 case studies, and that was when they would focus on a particular institution just to learn lessons that could be applied generally. And in Tasmania, it was the Hutchins School and SEBS, the Church of England Boys Society. But they didn't look into any government-related historical abuse allegations. And of course, once the Royal Commission started shining a light on those issues, it became very apparent that Tasmania, like every other jurisdiction in Australia, but Tasmania had its own particular issues in the way that government had dealt with historical child abuse allegations. And the government down here was under quite a bit of pressure to do something about it. And first they announced a Department of Education investigation, then they announced a Launceston General Hospital investigation, then they announced an Ashley Youth Detention Centre investigation, and it just became absolutely apparent that Tasmania needed its own Royal Commission, which is in fact what happened. In Tasmania, they're called Commissions of Inquiry rather than Royal Commissions. But the thing about a Royal Commission or a Commission of Inquiry, which was very different to all of those other sort of investigations, is that they have powers to compel witnesses to appear to give evidence, to compel the production of documents, and it's a much more rigorous process.
Right. Okay. And so that was a question I've just written down, was to ask, to clarify the importance of, at the state level, a Commission of Inquiry. It is completely, it's another degree higher, isn't it, than a departmental investigation or a report.
Absolutely.
Yes. Okay.
Yes.
And shall we move then on to what the Commission has uncovered, or in broad terms? So
I'll let you lead on that, Angela.
Well, yeah, sure. I think a bit of a focus of our discussion today is the Ashley Youth Detention Centre and the class action that we're running.
Yeah.
And even though the Commission of Inquiry is yet to hand down its final report, it was due on the 1st of May. They've asked for an extension, I think, to the 1st of August. I was very struck by by counsel assisting opening remarks. And so when you have a Commission of Inquiry or a Royal Commission, generally the evidence and the information is brought to the Commission by barristers who are known as counsel assisting. And in relation to the Ashley Youth Detention Centre, counsel assisting said, Elizabeth Bennett, SC, who's fantastic, she said, you'll hear in the course of this investigation, these public hearings, that there were many monsters at the Ashley Youth Detention Centre, but, and I'm paraphrasing here, she suggested that at the end of the public hearing, people would see that the Ashley was the monster.
Right.
And that was really striking, I thought. And certainly the work we've been doing, investigating the allegations, both of our lead plaintiffs and also the group members in the class action, and we can talk about that a bit more in a minute. The allegations were horrifying, terrifying. How could this happen? They're your natural responses. And again, the first inquiry actually into Ashley Youth Detention Centre, I think was in 1924 from memory,
yes.
Reggie.
Yeah.
So we're talking about an institution where serious concerns have been expressed for a century. And yet, not only did nothing change, you could say things got worse.
Yeah. And that's one of the so one of the reasons we're able to now run this class action is because the Royal Commission made recommendations about changing statutes of limitations. Now, the statute of limitations is in civil matters, you have a limited period depending on what you're suing for, where you can bring an action. In some cases it's 3 years, some cases it's 6 years, which you can also have extensions for in certain cases. But what the Royal Commission did was in Tasmania, the government decided that in matters of sexual abuse, serious physical abuse, or psychological abuse which arises from the sexual abuse or the serious physical abuse, that statute of limitations is abolished. So we are able to sue for as far back as we need to, and as far back as we have, of course, the evidence to back us up, which is a great thing for the victims who, until now, have not known that they can come forward and take that sort of action, which is really important for making some sort of resolution, because the criminal system, there hasn't really been any criminal convictions at all related to Ashley, or the actions which could be very much construed as criminal actions, because there was sexual abuse, there was isolation, there's throwing children into cells naked by themselves. This is all in our statement of claim, which has been made public. There's a public version of it, so it's no surprises to anyone. It's things that were raised in the Commission of Inquiry, where kids as young as 12, 13, 14 years old were strip searched, were thrown into isolation cells naked, sometimes for a day or two, and then sexually abused by guards. These are all the issues that we're dealing with now, and are seeking some sort of justice for those victims.
Can I ask you, and I think our audience or some people in the audience will be curious to know about the pragmatics of how a class action works. I should say I decided very early on. I also did my law degree down in Sandy Bay,
Yes.
And I was very much attracted to criminal law, and I'm a pathological optimist, which is so it's funny for me. So funny for me to gravitate towards criminal law and criminology,
Yeah.
but certainly a repeating area that I've studied has been on how to look after young people when they come into the justice system, because in a sense it's where there's the most hope to go as far upstream at least as the criminal justice system can, and to see what we can do better, of course, depending on all of the other absolutely essential things that the community does for children and young people to help them to flourish, so that the justice system's only a small part of the big picture. So for me, coming to this topic, I've got off topic a little bit, but what I wanted to say was it is just such an abrogation of the most basic duties of the state to have the most vulnerable young people in Tasmania treated in this way.
Yeah.
Even just neglecting them would be a tragedy. But this is obviously absolutely heinous types of abuse. Now, so I said what I originally wanted to just mention was that I decided very early on that I was interested in research and policy in the big picture. And I thought, well, I'm going to have to start closing doors at some point. And so even though I quite liked my moots, which if you don't know that word, it's like a mock court appearance for law students. I really got a buzz out of that. I decided that I wasn't going to ever practice as a lawyer. So I don't know much about the pragmatics of a class action. If you could tell us about that, or tell me, I'd be really, really interested. Obviously, I mean, there's some obvious things we could say, maybe kick it off this way. What are the advantages of a class action for a victim survivor compared with other avenues?
Yeah, and I just before I answer that, I have to agree with you there, Jeremy, and this is what makes what we're dealing with so sad. Horrendous and sad. Yeah. It's the fact that some of these kids were sent to Ashley for a very small, minor issue, some shoplifting or some, stealing a car where no one was injured, and then taken, and their life was made so much worse from the moment they stepped foot into Ashley, which has resulted in some really awful experiences in their lives afterwards. So you've absolutely nailed what we're trying to achieve here as well, and trying to highlight. Class actions, well, there is something to be said about this class action. It's historic. It's our first in Tasmania.
First ever class action.
The legislation changed to allow for class actions in the way they are done in other states. So it is a landmark case that will go down in history, and which, of course, we're very proud to be running. The beauty of a class action is we've got 134 now plaintiffs, group members, we have 4 lead plaintiffs.
So what is the role of the lead plaintiff then?
So the lead plaintiff will demonstrate what we're trying to show for the other 130 or so people that we have in our group. Now, these are very, very much classed as a silent group. The 4 lead plaintiffs, which we chose, and we talk with the plaintiffs, there's a lot of things to take into consideration. The breadth of the injuries that they've suffered, the breadth of the behaviours towards them. We've tried to get the 4 of them to represent all the people in the class. But that's not necessary. You don't have to cover every single type of activity, but that's what we've tried to do. So it takes that re-traumatisation out, first and foremost, for the 130, that they don't have to go through a singular process themselves. We're very grateful for the 4 lead plaintiffs who have come forward and are very happy to represent the other victims. So it takes that out of it, and it streamlines the process rather than having to do it individually. So that's one really great benefit. We have very experienced counsel as my lead counsel. So we've got Lachlan Armstrong, KC, who's done about 100 class actions or so in other matters, not in this world, but he's extremely experienced, and another counsel, Ben Slade, who's also very experienced in class actions. So we've got a really great team to cover that. I sort of work a lot on the human rights part, but we work as a really great team together, and it's of course our number one priority is to resolve this and make it is for our clients and for the victims.
So, thank you. So how do the other 134 come forward and identify themselves, and what threshold or what process do they go through to be included in the class?
I'll pass that to, because that's what the solicitors do, so I'll pass that to on that one. Yes.
Obviously, I said before, we started our practice in 2018, and we very quickly got a number of clients who complained about Ashley. I think the class action rules were brought in 2019, and so, at that time, before we could do the class action, we were thinking about individual actions. But one of the things about, the Ashley Youth Detention Centre, for example, is that a lot of the evidence on liability, should the state be held liable, what did they do? What did they fail to do? That evidence is common. And the alternative to doing the class action would have been to bring 134 separate actions, where in each one of those you would have to reproduce that evidence and repeat that story.
Yeah.
So not only is it about minimising trauma, it's about minimising cost for the members of the class action, but also for the state.
For the state.
Because
Absolutely.
ultimately, if this action is successful, the state will be paying out a lot of money and there will be significant savings on legal costs, for example. It's best that whatever money there is goes to the survivors, not to the lawyers.
Yes.
So there were those advantages, obviously. So once we started realising that we had a whole group of people who were telling us very similar stories again and again, and once the rules changed and we realised there was an opportunity to go forward with a class action, that in itself generated publicity, people talked about it. Yeah. I think when we launched the class action, we had about 100 group members. We've now got over 130. So the filing of the class action brought people out of the woodwork, even though at the time I thought, people must have been living under a rock if they didn't know about it, because they'd been with the Commission of Inquiry and there'd been a lot of it in the news. But of course, we are dealing with people who've had terrible trauma. We've spoken about the fact that often they came from disadvantaged backgrounds. Literacy is a problem, isolation is a problem, mental health issues are a problem. So it does take people time to come forward.
Sure.
And the great thing about the class action is, as people come forward, we can slot them in. We don't have to start from the beginning because someone new has come onto our books. So we expect that there'll be more group members by the time we've finished. We've actually put forward a closed class action that we say we're only representing the people who've registered with us. But at some point we're going to have a discussion with the court about that, because the whole idea of class actions is they're meant to cover a field. So at some point we're going to have a discussion with the judge about whether we can keep our class action closed. We'll have to, if we want to keep it closed, we'll have to put out publicity notices just to make sure that people aren't being left out.
Reggie, you used a phrase or a term right when we got going, trauma-informed. Can you tell us what that means? I mean, for you as a barrister, what does that mean in practice with how you interact with your clients?
So number one, and let me just say that's not just a term here, that's like a global term. And I say that simply because I'm at this very moment writing a paper on the response of the International Criminal Court Bar Association. I'm still involved at the International Criminal Court. Comments on how sexual and gender-based violence is charged internationally. And up front, I'm saying trauma-informed, victim-centred approach. Yes. And one of the key issues for being trauma-informed is the avoidance of re-traumatisation. So that's really key, because you need to employ methods. Every time you approach a next step in your case or a next step in your process, you need to think, how am I going to do this with the least traumatisation of the victim or the survivor? But you need to balance that, of course, against fair trial rights, against fair process and due process. So, which means that you need to still consider the other side when you're approaching. But for example, one way of doing that is to have a class action, which means that you don't, have to re-traumatise, put on the stand 134 people if we had to do that. The International Criminal Court did it in a way where there was a case against someone in Uganda who had committed crimes under Joseph Kony, the Lord's Resistance Army. Ongwen was his name. He's been prosecuted, lost every appeal, and he was found guilty. And to prove a widespread systematic attack in the form of sexual and gender-based crimes, it was enough for the International Criminal Court to have only 10 victims. And they took that evidence, before the trial, behind closed doors. They were still cross-examined, but in a very, very much less confronting setting, not with the cameras going. The court allowed that. So that is conducting an investigation and a prosecution in a trauma-informed manner. How few witnesses can we have on the stand to prove our case, for example, in the criminal context? How can we conduct any cross-examination that will not trigger and send, a survivor into another spiral? So these are all the things you need to take into consideration. And like I say, you still need to balance it with the rights of a defence, rights of an accused, and a fair process, procedural fairness, etc., in every aspect, but putting the victim first and ensuring they're not re-traumatised, or at least re-traumatised as possible.
Can I just jump in there though and say that we do have an adversarial legal system in this country and in Tasmania, and it's not the best vehicle often to be dealing with traumatised and abused claimants. And one of the other things the Royal Commission into Child Abuse did was recommend that a national redress scheme be established so that survivors of childhood, and it's only sexual abuse, childhood sexual abuse, can claim compensation through the redress scheme. There's a lower standard of proof. We've got the criminal standard of proof beyond reasonable doubt, the civil standard of proof on the balance of probabilities, and the redress standard of proof is reasonable plausibility. Yeah, so, or words to that effect. I always forget the exact words, but it's something like reasonable plausibility. Survivors who want to apply for redress, they just need to fill in some forms. They don't have to prove their allegations. They don't have to be medically assessed. They're not cross-examined, none of that. But of course, the amount of compensation which is delivered through the redress scheme is generally much less than what you'll get in a successful civil process.
Right. And what Angela, just to jump in, what Angela's just demonstrated there is also, from a trauma-informed perspective, is the victim survivor has the choice. So that's key to being trauma-informed. You have options. You can go down, you can try and press charges through the criminal system if you want to. Of course, you need the assistance of law enforcement and the prosecution to do that. You can go down the redress scheme, or you could go down the civil path. However, the choice of which way they want to go is in the hands of the survivor.
Yes.
That's a really key aspect to a trauma-informed approach.
Having autonomy or agency.
Exactly, that's right.
Yeah. So, with regards to the class action, and I appreciate I can't ask, well, there will be details you can't discuss and so forth. So, just in broad terms, I'm thinking of the type or the type of claim that has been brought. Is it one of negligence?
Yeah, so negligence in the first instance,
Yes.
which is you, Tasmanian Government,
Yeah.
failed to take reasonable care
Yep.
and avoid foreseeable risk of injury of
Yeah.
our clients.
Yeah.
So to prove negligence, we need to prove knowledge, poor supervision, all of the risk factors. We also are making a claim vicarious liability.
Yeah.
We're saying to the state, so even if you didn't know that some of these abuses were going on, and mind you, we say they did know and they should have known, but even if you didn't know, in particular instances, you placed the people who we say abused our clients in a position of power, trust, authority and control. And if they exploited those positions to abuse our clients, even if you didn't know about it, you should still be held liable. And we've also pleaded, or we're in the process of pleading a number of intentional torts, which relate to the actual assaults that officers intended to hurt our clients. And that brings in things like false imprisonment in some cases. Regina.
Battery.
Yeah, battery. Yeah.
Yeah.
So, it allows us to, the intentional torts also allow us to look a bit more closely at, things like the scabies cream. Kids going into Ashley were coated in this horrible burning scabies cream. They were strip searched. Sometimes we say the strip searches amounted to sexual or physical abuse. Other times we just say they're inappropriate. So, there are our statement of claim is currently about 50 pages long, I think.
Right.
And will get bigger as we go along, because as we discover more, we'll be looking at including further allegations.
So I'm really curious, because it's been, 12 or 13 years before I really, but since I've taught in torts. I won't go down this path for too long, don't think I'll gosh down the more.
You've got the expert here.
So with negligence, what about proving damage?
Okay, so with our lead plaintiffs and with our group members as well, we've sort of got two paths going along. We call it the trial path and the mediation path. So, the state of Tasmania has expressed an interest in trying to resolve these claims. Hasn't said they will, but has expressed an interest in it. So whilst we're preparing all of the liability evidence, we also have to start investigating and getting evidence of impact and injury, loss and damage.
Yes.
So with our lead plaintiffs and with our group members, that means having them psychiatrically assessed, collecting medical records, collecting financial records, because we can claim for our clients damages for pain and suffering and loss of enjoyment of life, loss of income, the cost of treatment, and also aggravated or exemplary damages, where we ask the court to award those damages because we say that the state has behaved so badly in allowing the abuses to occur that they should be punished over and above compensatory damages.
Yes. So those are also called punitive damages?
Yes. And don't ask me about the difference between exemplary and aggravated, because I always get mixed up.
Yes.
But they are basically punitive damages to punish the wrongdoer.
Yes, and to make an example of
Correct.
And one of, you have the basis for aggravated damages is, where, as Angela said, where the state knew and allowed it to continue. And, that you see that in civil cases as well, where, someone was reported the abuse and then the state or the institution, the church, whoever, did nothing or simply moved the perpetrator along somewhere else to a different school so they could start perpetrating or institution. And that is a grounds for aggravated damages because it's behaviour that perpetuated it when they could have stopped it. So it's a punishment,
Yes.
But in Australia, exemplary and aggravated damages are very low. Right. In individual child sex abuse or sex abuse cases, the range of exemplary or aggravated damages is between $30,000 to a top of $150,000. Whereas, a lot of our listeners may be aware more of the American experience, where millions and millions are awarded in punitive damages. And just to give an example, which, I think is quite well known, but, there's the case of the little old woman who went to McDonald's and bought coffee, and as she was driving off, she spilt it and she suffered burns. She was awarded many millions of dollars, and people looking at that would think, was a burn, like, it was coffee. What's it all about? But in fact, the evidence in that case was that McDonald's, if they overboiled the coffee beans, could make them last a lot longer, produce more coffee cups, sell more coffee, and I can't remember what the profit was, but some huge profit across all of the McDonald's stores. And they knowingly did that. They boiled the water too high, too much. So when you look at that, you understand that, yes, punitive damages definitely have a role, and McDonald's stopped overheating the coffee and therefore avoided other similar incidents.
This is just so interesting. I glanced at the time, and I really think, particularly with such a heavy topic like this, I really would like to ask you both about to take some two next steps in our discussion, and they might not take long, but firstly to draw out the lessons of what the state did wrong. We could dot point those with a view to thinking how we're going to make things better for the future. How do we avoid this? In another decade or two goes by. Commission of what? 2023? We're in the 2040s now. You can just imagine it happening. So if you were able to dot point what you thought, I don't mean legally, I mean how in plain terms what were the things that went wrong and that deliberately, I just don't mean by accident.
You can start off.
About the system.
So some of the things we saw and that the Commission of Inquiry has highlighted is that there was a lot of nepotism at the Ashley Youth Detention Centre.
Right.
That it was a very closed community. It's located in the northwest in a pretty remote location. It's probably the biggest employer in the area, where employment is not great, employment opportunities are not great. So that the people who got into Ashley were determined to hold on to their positions and to bring in other people who they knew. And so there was really very little independent oversight. It was like a closed community. And every time there were complaints about Ashley, and we said the first investigation was in the 1920s, the government was very reluctant to do anything about it because it was a big employer in the area, and politically, if they'd moved to close Ashley down or to get rid of people who were there who were problematic, that would have caused a lot of waves. So I think that was one of the key reasons why Ashley was able to become the monster that Councillor Sisting described. But I think probably more importantly than that, the people, we talked about the vulnerability of the kids there. They were already probably damaged before they got into Ashley. Very occasionally you'd get a kid who had no sort of history, but mostly they were troubled kids. By and large, their parents wouldn't have been in a position to advocate or agitate for them. A lot of poverty, a lot of isolation, a lot of mental health issues. So, it would come out from time to time that there were some problems, but never in a way where the government, I think, actually felt under pressure to do something about it. But following the Royal Commission, where all of these issues were brought to light, I think there was more and more advocacy, more and more agitation, and something was finally done about it. Was that your question, Jeremy?
Yeah, that's absolutely fascinating. I was thinking of it from a criminological perspective.
Yeah.
What's the story here and what do we learn? So that nepotism dynamic, did that apply to the operational staff, if you like, or did it also go up the chain a little bit? So did you have people
Yeah.
who were friends or relatives or whatnot, who were decision makers who...
I can't say that I've got direct
Don't know,
evidence of that. It was mainly in the officer class.
Yeah.
But the higher ups didn't want to deal with the problem. They didn't want to deal with the problem.
Yeah.
And, you know, no doubt over the years they formed relationships with the managers and that sort of thing. So there was no appetite to fix it. And you're absolutely right. We don't want that to happen again after all of this time and effort and money.
Yeah.
We don't want it to happen again in 20 or 30 or 40 years. But to be fair to the Tasmanian Government, through the recommendations of the Royal Commission, and no doubt through the recommendations they'll get from the Commission of Inquiry, there's been very, very significant legislative change.
Excellent.
So that children in Tasmania going forward are much more likely to be protected. You can never stop it.
No.
You can never stop it, but you can do as much as you can to keep kids safe.
I might just briefly mention also a new part of our landscape, which is wonderful, and that I think all Australian jurisdictions or most jurisdictions have is a special hearing scheme or special processes that have been implemented for victim survivors to be able to give their evidence in ways that minimise the risk of further harm. Maybe should we wind up? We should wind up at some point. It's not fair for me to keep you both talking. Should we wind up talking about OPCAT, which is, I had to write it down.
The optional protocol to the Convention Against Torture.
Yes, and other cruel, inhuman, degrading treatment or punishment.
That's it.
So we call that OPCAT, and over to you.
Yeah.
You know,
Oh, look,
what
I can talk a little bit about that, and I think actually just to follow on from what Angela was saying there in that question you asked before is, you know, one of the issues that you see also looking retrospectively is that not even the basic rights under the UN Convention for children, children's rights, were covered at Ashley. You know, that the very basics that the international community demands of states that are not rogue states like Australia, we're supposed to be a model state under international law, we couldn't even meet the bare minimum in these sorts of institutions. So that going forward needs to be key and at the forefront of any process now, whether or not it's a type of detention centre, which, you know, children should not be going to jail, but that the UN Convention for the Rights of the Child are at the top of any priority, which leads nicely into OPCAT.
Yes.
So Australia has signed up, as many countries have, to the United Nations Convention Against Torture, other inhumane treatment, etc., which we call the CAT. A little side note is that the UN Special Rapporteur on Torture is also a graduate from the University of Tasmania, Dr. Alice Edwards. She's a friend and she's doing incredible things. The world looks to her for guidance on torture and where torture and mistreatment is taking place, and she's been very vocal. So it's another person that, you know, Tassie should be very proud of. Another woman in that, she's the first woman to take that role as well, which is an extra added, point of admiration for people like us and women in law. So OPCAT is the optional protocol, so it's an additional, let's call it an addendum to the Torture Convention, which Australia has also signed up to. And what that asks of member states is to create what's called a national preventive mechanism. So, you know, what we're doing here is dealing with things that have gone wrong. A preventive mechanism is to prevent it in the future. It's not an investigative body. It's not someone who comes and investigates things that happened previously. It's a body that can come into a location like the Ashley Youth Detention Centre, like anywhere where someone is detained against their will. That can extend to aged care facilities, we say. And they go in and they can inspect at a moment's notice, so they can give you an hour's notice, which is often a very important element of surprise. to walk in and say, here are the things that you need to do going forward to prevent anybody being treated, ill-treated or tortured. Torture is a very broad concept, but to be ill-treated or not have, to be treated as a human or in an inhumane way. So that's what that national preventive mechanism is. Now, you may have seen in the news that Australia, very embarrassingly, had a delegation come from the UN to try and inspect some of these places of detention already. And Queensland and New South Wales did not allow them to go and visit certain places of detention, as we should have. And they had to leave the country without fulfilling their mandate of inspection. That's embarrassing, and we're about to be labelled as non-compliant, which as a member state under international law, as a model state under international law, should not be happening. What I can say, and what I'm very proud of, is the fact that Tasmania is leagues ahead of other states in implementing this national preventive mechanism. I've been involved a little bit in that, which has been great. The Ombudsman is wearing the hat of the national preventive mechanism. He wears a lot of hats, and he's creating an office which will give the parameters of this national preventive mechanism and where the people can go, the inspectors can go. So at the moment, it's at a consultation process where they're asking civil society for comment on, what do you think this should involve? It's really important to involve civil society in that process. So that's where we are there. So that's one of the things that, the dot points you were talking about, and it's a nice lead into that going forward, that we have systems in place that will prevent, there will always be something, we cannot say zero, that's never going to happen. But we can do our very best to prevent. Another way, of course, is to have independent complaints oversight, as Angela was talking about. They're all systems that can be in place to ensure that our kids of the future don't go through what the kids or the adults that we're dealing with when they were children dealt with back then.
You just said that so well. Thank you so much. I think from my background in crime prevention and basic principles in crime prevention, what really appeals to me about the model that seems to be emerging in Tasmania for the custodial inspector is the fact that at a moment's notice, they can physically inspect and walk around the facilities, and also without interference and individually talk to people with, actually, depending on circumstances, with people who might not be the inspector, for example, who has the skills in trauma-informed, dialogue and interaction, but to actually hear from the people, let's say, if it's young people in detention, about how are you going? You're not being listened to here. This is safe. You can tell us.
Yes.
I just think that one thing, that aspect of transparency, independent, greatly reduced risk of nepotism, concern about the next election and employment in an area. I think that's one thing that will be a reason for hope for the future. I think, as you both said, you'll never be able to permanently stamp out abuse of children, as sad as that is to say, but reducing its prevalence dramatically in areas where, you've got state resources and a state-run institution ought to be achievable. I think, shall we wind up there? Can I thank you both, Angela and Reggie, it's just been great meeting you.
It's been a pleasure.
It really has, it really has.
Absolute pleasure.
Good.